Hello and welcome to Daily Politics on Trust TV. On this program, we discuss issues around politics, policy, and governance. I am Hamza Idris. Nigeria's Affiars Court, the Supreme Court, on Thursday ruled that it is unconstitutional for state governors to hold funds meant for local government authorities under any guise, just as it described as non-negotiable and sacrosanct a democratically elected local government as against a contraption called caretaker committees. In its ruling, the seven-man panel of Supreme Court justices led by Justice Emmanuel Agim, which held that a local government council is only recognizable with a democratically elected government, also barred the federal government from crediting funds to the third tier except directly to the elected local government councils. Recall that the Attorney General of the Federation and Minister of Justice, Lateef Fagbemi-San, filed a lawsuit on behalf of the federal government seeking full autonomy and direct funding to the 774 local government councils in Nigeria. With the Supreme Court judgment, millions of Nigerians living in the 774 local government council will now expect development to trickle to the grassroots after several attempts, including an executive order by the previous government, failed to liberate the LGAs from the shackles of state governors. And it is against this backdrop we'll be engaging with a legal practitioner on the expected impact and implications of the Apex Court ruling, Barrister Umar Aminu Kalgo. He is the Secretary Nigeria Barr Association, Birnin Kebbi branch. He joins us via Zoom from Birnin Kebbi, the Kebbi state capital. Thank you very much for joining us, Barrister.
My pleasure.
All right. We also have in the studio a public affairs commentator, Comrade Salihu Mahmud. Thank you for coming to the studio.
Very good evening.
But before the conversation, here are some tidbits. The Catholic Bishops' Conference of Nigeria has urged the federal government to immediately propose amendments to the controversial Samoa Agreement or withdraw from it if such amendments were not accepted. This is contained in a statement titled Threats to the Sovereignty and Values of Nigeria in the Samoa Agreement on Thursday, and jointly signed by the President of the Catholic Bishops and Archbishop of Owerri, Lucius Iwejuru Ogoji, and Secretary of the group, Bishop Oromi Donatus from Ogun State, respectively. Daily Trust reports that there have been controversies on the agreement, especially on the fear that it involves legalizing same-sex marriage or support the agitations by the lesbians, gay, bisexual, and transgender LGBT+ community for recognition as conditions for getting financial and other supports from advanced societies. The development has also led the federal government threatening to file a lawsuit against the Daily Trust newspaper over its report on signing of the Samoa Agreement. Our correspondents also report that some clerics, rights activists, and civil society organizations have expressed outrage over the decisions of the government to sign the controversial agreement. And the Federal High Court in Abuja has ordered that a former Minister of Power, Salihu Mahmud, be remanded in Kuje Prison, Abuja, pending the consideration of his bail application. Justice James Omotosho issued the order on Thursday after the court resumed Mahmud's arraignment on Monday on alleged laundering charges, which was earlier stepped down by the judge. The former minister pleaded not guilty to the charge and prepared against him by the Economic and Financial Crimes Commission. The EFCC had filed a 12-count money laundering charge against Mahmud. He was alleged to have committed money laundering offenses to the tune of 33 billion naira. During the hearing, the minister fainted in the court. The former minister served under former President Muhammadu Buhari between 2019 and 2021. We'll now take a short break. When we return, our conversation commences. Stay with us. Welcome back. Yes, we'll start with Barrister Kalgo. Yes, what is your take on the decision of the court in Abuja to remand former Minister Salihu Mahmud in Kuje Prison, despite the fact that he fainted in the court?
I would say the justice is a blind. You can see from the symbol of justice that justice has no favor. It is only the law as it is. And now having a ruling that have ordered for his, remand, detention, therefore, that order must follow through. And the correctional services have facilities that ought to have taken into consideration his health issues, and if demand or need be that he need attention in a facility or a government hospital, I know that's how it should be carried out. All I want to say here is, look, the law, as you can see, is there after, because just the phantom that we see is something that emotional, but he must have undergone a rigorous, the judge must have gone a rigorous assessment of of what is before him, pertaining to consider whether there is need for him to be remanded or not. So in that case, I think the law, we should look the law as it is, and do not bring sentiments into it or other passion or other, emotional considerations. And the law is there so that we can have a decent society and law and order in our country. And without such measures being taken, the civilization we envisage to have will not be. So I just want to say, as fellow Nigerians, we should identify with the processes of the court, because we have no option but to, receive the law as it is and respect it.
All right. Thank you very much, Barrister. Yes. Comrade Salihu, what is your take? Because we don't want to go deep so that as not to jeopardize the court process.
Yeah. Well, thank God the legal luminary has thrown some legal view to it.
Yes.
The issues are, once you are under investigation, you remain a suspect. It's an allegation. The remanding in prison is pending the outcome of the case that is before the court, because this is a case of alleged corruption, money laundering.
Yeah.
And it was brought by one of the anti-graft agencies, which is the EFCC.
Exactly.
And don't forget, not long ago, one of the Buhari ministers, former in charge of aviation, Adi Sirika, also went through that over 2-point-something billion allegation on corrupt, what have you. So Salihu Mahmud is not the first. Then Sadia Farouk, don't forget, also from humanitarian ministry during Buhari administration. You see, the issues are first in history. One party. The transition was from APC president to another APC president. This is not to say maybe it's persecution, not at all. So this is one party issue.
So it's a credit to the democratic transition.
That is it. That is to tell you that our democracy is thriving, devoid of favoritism, devoid of I know you, devoid of maybe godfatherism and what have you. Ordinarily, maybe the former president, knowing that they were his ministers. Don't forget, even the former president said, after I leave office, any of my ministers or aides found wanting, do not call me to come and answer, call them individually, because I gave them responsibility and they swore to protect treasuries and interests of Nigerians.
Thank you. Thank you very much, Comrade. Yes, now the other issue before we go to the main issue of the day, which is the LG financial autonomy or full autonomy. But what is your take? The Catholic bishops, the Catholic lawyers, and also the Islamic Foundation of Nigeria, today they all ask the federal government to scrutinize, or in the alternative, drop the Samoa agreement. As a legal practitioner, what is your take on all the back and forth around this agreement?
I think as a legal practitioner, the law should not go, social issues affect law, and also vice versa, it is always like that. And I would say, I can understand from the point of view the Catholic bishops are coming, because it is well known that in our country, Nigeria, the issue of same-sex marriage, we have an act that have prohibited same-sex marriages, and also even sodomy. So, and in the claims overseas in the Western world, particularly Europe and US, we all know the stage at which they operate now concerning these issues of sexual orientation rights and what have you. Though there is back and forth as to whether this issue of same-sex marriage is explicit in the Samoa agreement, I think that can be contested. But I believe there are words that still could carry out that meaning. So if you look at just the difference in our perspective toward this issue, as a country, Nigeria, we have an act already. So we are operating from different levels regarding to that. So if there is a great apprehension, as we see from the Catholics and the Islamic clerics, and I think whenever you see something heated to this level, I think whatever is there, a due consideration should be given to that. The fear of the populace, and that's why we have democracy, so that people could be heard. These fears that people exhibit and show should be something worth consideration from the government. I know there are statements from the government that try to appease the mind of citizens that that is not it, but all the same, I think it should be very accommodative in responding to what these yearnings on ending coming back and forth. So I will say this is both social, political, and legal issue to consider.
All right, thank you. And Barrister, I want to quote from Professor, of course, Shuaibu Zunnurain. He's a professor of law, and they held a press conference in Kano today under the auspices of Islamic Foundation of Nigeria. He said, even though the LGBT is not explicitly written in the Samoa Agreement, gay and homosexual rights were enshrined using other terms. The law proposal said the 2018 agreement, which had protection of the rights of gay, lesbian, and transgender, was rejected by 30 countries in Nigeria, including Nigeria. He said, though the LGBT were removed, in the new draft, terms like gender, reproductive rights were actually meant to protect LGBT and abortion rights. He said framers of the 1999 Constitution were sensitive enough to use the term sex instead of gender in Section 42, dealing with non-discrimination against persons on account of his sex, ethnicity, or religion. So they outrightly call for the dropping of the Samoa Agreement. As civil society activists, where do you belong?
I'm against it because here in the country during the Jonathan administration, he opposed it. The immediate past Muhammadu Buhari administration opposed it. What now led the Tinubu administration into signing it? Is it that the Ministry of Justice or Attorney General's office is not doing what it ought to do? Or is it that there are certain aides of the president who stand to benefit certain indirect? Because there are allegations that in the system, there are certain kickbacks that goes, even though it remains an allegation, maybe from some foreign countries and what have you, before sentencing comes in. It is very possible, if not, why? So the issues are whether the government actually made attempt, whether the government signed it or not, just like what happened in Kenya, and you see President Ruto had to withdraw funding for office of his wife. So I think President Ahmed Bola Tinubu, if he believed that Nigerians were the ones that elected him, Nigerians, irrespective of tribe and religion, are saying no to that Samoa LGBTQ agreement, whether it's signed
even
or
not explicitly
even if there
stated.
was if there is an intent to do that, it is a better time for him to say no. And it doesn't take Mr. President anything to do a kind of national broadcast by way of saying, come, I did not sign it, and these are my defense. We're in digital age. If, of course, you didn't sign it, there are evidence you can show that, yes, maybe requests were made, I didn't make that.
Actually, you can see the Minister of Information and the Minister of Budget, they all admitted that they signed it, but they vehemently rejected the argument that even the wages.
What the legal luminary, the legal professor now said, rephrased.
They were
using
rephrased.
other terms.
Exactly.
So that is to tell you there is a gimmick in the whole matter.
All right. We hope we find an amicable way of resolving this problem. Now, Barrister, back to our subject of discussion today. The Supreme Court said governors should not touch the finances of local government areas. What is your take on this? Because even during Buhari, there was an executive order to this effect. And even in the early days of President tinubu, they said monies should be going directly to the accounts of the local government, and they should be given powers to do what they think will be favorable to the electorate. So what is your take?
I think it's a great day for Nigeria, and this is something that clearly have been pursued also too long, but greatly today it has come to pass, the independence of the local government council. I believe a lot of Nigerians, the majority of Nigerians, will give a sigh of relief with this judgment. And the way the saying that goes, the phrase that always say that the law is an ass, I think today Nigerians would be saying, no, the law has a human face. Because once you look at the judgment, you will believe that it is a progressive interpretation of the law, where the courts has leveraged on the intendment of the Constitution as opposed to, literal and dogmatic pursuit of, literal interpretation of the law. So I would say a big, thumbs up for the Supreme Court of Nigeria, having come of age with departure to this judgment of today. And the courts reiterated this very fact, that this is a progressive interpretation of the law, and it has looked at the position that since paying to the state government is not effective pursuant to Section 162, sub 6 of the Constitution. So now the interpretation of the Supreme Court stands, and I will say this will go a long way in facilitating our federal system of fair tiers of government. Because all the way we have been suffering at the local government tier being inoperative to the level that is supposed to be as a tier of the federation.
Okay, I will come back to Section 162 so that we can dissect it in more details. But let me have the take of Comrade Salihu here. Will it make any difference to the man in your local government, in my local government, in the local government of those watching us? Will it make, there are many laws, they are clearly defined by the Supreme Court, but you see the governors respecting them in abeyance.
Well, for now, I'm jittery.
Okay.
Because if you still have state independent electoral commissions conducting local government elections, the verdict of Supreme Court making allocation of local government funds to go directly from federation account to them, other than the state joint account, will still stand as if like doing something
neo-colonialism of sorts.
That is it, because who controls the chairman still? The governors. Who controls the civil service machinery of local government? The governor. For example, the Ministry of Local Government in states, Local Government Service Commission, posts treasurers for local governments, posts directors of personnel for local government, and other senior staffs. Those that the local government chairman have powers to appoint are maybe from level 1 to 6. So if, for example, the governors know that, yes, this verdict is there, and they have their emissaries, like the council treasurer, like the director of personnel management, and other HODs coming from the state, indirectly, they can initiate fictitious projects to say, yes, let's do this, let's do that. And when payment is to be made,
they are the signatories.
That is it. So, except if the modality of election is changed from state independent electoral commissions to INEC. Just like I think there's a portion of it in that judgment too. I have not truly gone through it.
Well, yeah, the section was talking about having elected, not who conducts the election.
So the issue, they also need to look into that, because during the military, we all know, most local governments were supervised by Office of Chief of General Staff, which is like Vice President. We grew up to see where Augustus Aikomu, that was Chief of General Staff, who later metamorphosed into civilian Vice President to military President Ibrahim Badamasi Babangida. Local government chairman used to come as far as Lagos and Abuja to hold meetings. So if during the military that ruled through decree, local governments were under Office of Chief of General Staff, that is like Office of Present Day Vice President, then what is wrong under democratic institution? Then again, don't forget, before this...
Okay, you are now saying they will be better off under maybe Office of the Vice President instead of being under the
what I'm
government.
saying is that ITATO, local government supervision, was under Chief of General
and even in
Staff,
1999, I think it was NEC, then the National Electoral Commission, that
Chief of
conducted
General
the
Staff,
election.
because under the military, the Chief of General Staff is like Vice President.
All right.
So that's what I'm trying to say. So the issue I'm saying now, even before the Supreme Court, but don't forget, during the immediate past Muhammadu Buhari administration, he had asked the Nigerian Financial Intelligence Unit to make direct allocation to, before the governors went to court.
Yes.
So let's hope these areas, gray areas, will also be addressed, because if the allocation goes there and the governors still control the election machinery and whatever, they are still control there. So indirectly, they also have avenues to still be in charge of the funds.
All right. Now, Barrister, Section 162, subsection 6, 7, and 8 says, each state shall maintain a special account to be called State Joint Local Government Account, into which shall be paid all allocations to the local government councils of the state from the federation account and from the government of the state. Now, 7 said, each state shall pay to local government councils in its areas of jurisdiction such proportion of its total revenue on such terms and in such manner as may be prescribed by the National Assembly. And then 8, the amount standing to the credit of local government council of the state shall be distributed among the local government councils of the state on such terms and in such manner as may be prescribed by the House of Assembly of the state. Can we say now the Supreme Court judgment of today overrides the Constitution provision, or vice versa?
No, we can't say that it's overrides the Constitution, but rather is the interpretation of the Constitution. Before I further elaborate on this, please permit me to respond to what Comrade has said regarding whether it's going to be effectual or not, what the Supreme Court judgment is all about. I want to say we should chew our food at a time. The issue of local government election is another issue entirely, which me too, I share the same view that if it is taken out from the states, I think it will be a better thing, looking at how better the election conducted by INEC. But I think we should not downplay the achievements of today, that they will have this financial autonomy of being, the money is being paid. So that brings me back to your question. I want you to realize that this interpretation is very clear and in simple terms. Before, the position was that it can be paid. The courts clearly said that the position before is that it can be paid through the state joint account or directly to the local government. But now it has, since, that's why we say it's a progressive interpretation. Since that payment, that mode of payment have been faulty all the while, or have not lived up to the expectation or the purpose for what it was done. Now, this is the interpretation. And let me be very clear that the separation of powers, the legislature have the power to make the law, but it is the court that interpret the law where you have conflict or disputes. of interpretation between parts of the executive or parts of executive and legislature. And now you have a conflict between the state governments and the federal government, and the Supreme Court have come to interpret the law. So the situation is that the courts can seem to make law where it comes to interpret the law. So it's not overriding the Constitution, but giving an interpretation of the provisions of the Constitution.
And if I understand what Comrade said, he said this financial autonomy has been there for a very long time. Of course, during Buhari, the Nigerian Financial Intelligence Unit also said, look, allow local government administrations to have control over their funds. And the governors rushed to court. So his fear is that maybe, I don't want to use your decision and speak for you. What you are saying is maybe unless there is constitution amendment where maybe this joint account will be separated. Is that what you are trying to say? I will come to you, Barrister.
I think, yes, that is what I mean. Because if that joint account still exists, honestly, it's a barrier. Because the local government chairmen, most of the times, they fear these governors. Because some of them treat them like maybe my boys, because I made you.
They were instrumental to their.
That is this. Just look at what the outcome of local government elections normally become, where you hear if it is PDP that is in charge of, okay, like Oyo State, where Makinde is governor.
For instance, yes.
PDP won virtually all the local governments.
Almost every state.
Local government election in Kwara of recent, APC, because Abdurrahman is of APC, the governor, His Excellency, APC won virtually all the local governments. Same thing extends to other states that held the elections. So these are some of the issues where what we see externally differs from what happens invisibly. So that is another greater fear I have.
All right. Barrister, you heard what Comrade Salihu said, that his fear is if there is that marriage of convenience in the name of joint account, is as good as the local government chairman will remain in the pockets of the governors. Will you agree with him? And what will be the remedy?
I believe the judgment have allayed his fears. I know it's a new development. We have been pursuing this judgment that come, but I have read in the Punch newspaper, and there was a quotation from the judgment, which now says, it says that the allocation from the federation account should henceforth be paid directly to the local governments. And with the judgment now, this issue of joint account should not be something that should be too much worrisome to us, because the federal government, from the federation, if they pay directly to each local government, it's not contradicting the judgment. I want us to focus on what this interpretation is giving. Now we cannot go back. The understanding of the Constitution should be the one that comes from the Supreme Court. That's what interpretation is all about. And previously it has not been the case because the governors have rushed severally to the courts. So you see, in interpretation, there are canons of interpretation, which, guide the courts. And there are times when the court use the canon law of literal interpretation. And there are times when it look at what the mischief, which certain or the intention of the legislature, and now it fashioned its interpretation towards the greater context of the intention of the legislature. Once you look at our Constitution, you will know that these tiers of the federal government are there to have their own finances and to exist as autonomous, to achieve and have financial autonomy. So I think we should imbibe the spirit of this judgment, and it has allayed most of our fears. And also the issue of, and it has a mechanism in the judgment that will aid the government at the center to ensure compliance, because from henceforth, this allocation of funds should only be done to democratic elected officials of the local government. Many states don't have, presently many states don't have democratic elected officials managing the local governments. They have appointees. You can see, and this has been, it's not proper in law all this while, but how do you get enforcement was the problem. So now this judgment have come with many innovative ways to ensure that, these things were achieved. We should give kudos to the Minister and Attorney General of the Federation having achieved this. During the Buhari regime, administration, we have strived to achieve this. He did that by giving, the executive order, but you see, it did not see the light of the day. So I think it's a progress that we have achieved, and we will, following this day, see how interesting this judgment will be on ground to address what we have, because in my state currently we don't have elected officials manning our local government. Thank God we are moving into election just next month, but before next month, this month is going to end, and I don't know how, but the judgment of the Supreme Court always starts immediately because that's the final judgment, so it should be implemented instantly.
All right, thank you. Now, the other issue is, I don't know, maybe you are satisfied with what he said, but the other side to this is, if these funds get to the joint account, there is the likelihood that, of course, it has reached the local governments, but the governors, because they have power, they can ask the chairman how to actually utilize the money, or even where they should now channel the money to.
I agree with Barrister, because the issues he raised are, one, you have in some states caretaker committee chairman who appointed them, the governor. So that is to say, if they are able to access these funds, they will use the funds at the discretion of the governor. For example, if maybe a local government in Rivers is getting 2 billion, maybe Obiakpo local government is getting 2 billion. Now, with the governor having the caretaker committee chairman there, might say, okay, I want so gas pipeline area, that is what have you, in terms of this, collaborate with Shell and what have you, let us make our own contribution since you are the local government there. Then if it, for example, if it is Kayama local government area in Kwara State, maybe there is a road that is abandoned by federal government, so maybe, okay, let's look for one local contractor since it's immediate priority, go and do this way, this I want to do it. Then the bill of quantity, then the architect, the civil engineers and what have you will be determined by me. Or maybe, for example, if it is Kebbi local government, for example, the governor also dictates. So it is when they are also able to have elected local government chairmen in states that this can also work. Again, I raised an issue for you earlier. The state electoral commissions conducts the election.
Yes.
Then the parties, even the nomination and what have you, don't forget the governors also have powers. So most of the chairmanship candidates that emerge, maybe they are their candidates. So it is what they want that they will do. If they decide to say, okay, use half of the money, bring half of the money to state capital,
they will do it.
Because the only thing they will only do formality in fear of EFCC. Because if they make the withdrawal maybe in the state capital, maybe after the CBN withdrawal, what have you, there might be suspicion.
They're allowed
to go there, then in turn bring it back to the state capital.
So let's bring Barrister here. Do you think there is any difference between caretaker chairman and so-called elected chairman, considering that it's very unlikely, even in the states where you have elected chairman, to see even a councillor from the opposition party, not to talk of local government chairman? So what difference does it make to conduct election or to even anoint?
To me, they are even uncomparable. You can't compare where people have exercised their franchise and elected someone. Yes, and in a situation where that that right was not even accorded to citizens. Please understand me here. We are talking of system. Yes. A system can be abused. An elective system can be abused. But when you say it now, but abusing an elective system is different from not even having it. So what we are saying that you cannot compare a situation where the franchise is there and where there is no franchise, people are just appointed. And secondly, I want to also further elaborate about this judgment. The interesting thing about this judgment is it gives a declaration and prevented the funds to be released wherever you have appointed local government officials. The federal government should not release the funds for that local government. You can see that is an implementation strategy which will eradicate such occurrences in the future. So there are interesting things in the judgment to focus as we move ahead in the days to further elaborate on this. And I want to say regarding the local government, the question of election of local government, I think is entirely different from what we are discussing today. I'm not saying it is perfect. I have my views about it, but I focus on the issue of, the autonomy of local government towards harnessing and using the funds allocated to them, and also the issue of having elected officials. You see the issue of corruption. When you say somebody has dishonestly not used his office, is another question. You can always find people in every facet of their life and official duty, whoever in his own entitlements and rights and his office sway towards being dishonestly discharging his duties. Such things can fall through. That's why corruption would be the other thing that will be causing such issues that Comrade is complaining, whereas you find maybe a local government chairman conniving or what have you. But I want to say that this judgment, as it improves our system greatly. Yes, that's no doubt about it.
All right. Comrade, in 1998, ahead of transition to democratic rule, during Abdul Salam, that was when we had election. There was election for local government areas conducted by the military. And that was when they started getting their money. And they were able to do a lot of issues. But around 2003, that was when we began to see some lacuna in the administration of local government chairman. And many people believe it is around recruitment process, that you then get people of quality, people of caliber who know how to administer, clinching the seats of local government chairman. What will you advise in terms of recruitment process? Because you must have two to tango. If you have the money, if you don't have the right people to administer it, you may not get it right.
You see, some of the impediments the local government system also has is area of recruitment. Like I mentioned, fortunately, I was a chief press secretary in Gwagwalada Area Council from 2002 to 5 during Honorable Issa Dobi administration here. Okay. I know how it works. Like in the FCT, for instance, you have the Area Council Service Commission. Any senior officer from level 7 upward is the purview and jurisdiction of the Area Council Service Commission to recruit and post to the 6 area councils. So the only ones the local government chairman has right on is from level 1 to 6.
He can recruit without recourse to anybody.
But from level 7, it is the duty of Area Council Service Commission. Same thing extends to states. You have a local government service commission where you have the chairman, you have commissioners representing different areas. So for senior staff recruitment, it all comes from the local government service commission. So the only one the chairman has input is the junior staff. So this is also another impediment and a big problem, because once a senior staff, for example, a treasurer, is being posted from the Ministry of Local Government or by the Local Government Service Commission to your local government, you as chairman have limitation over its control because the allegiance goes 100% to where he or she is coming from. And these are some of the problems they have, except if that aspect of the process is amended. Maybe the state houses of assembly, the house committees in the state on local government can maybe amend that or review that portion of recruitment. If not, it will remain the same thing. So issue of saying a chairman maybe with the direct assessment of funds from federal government to have quality, what have you, the only quality staff he can recruit is from level 1 to 6, just the way I emphasize. So you can see it's another problem. So there are many impediments
that must be corrected,
from election conduction to even recruitment of staff. It's just like the issue of that is happening now. Let me compare with police. Just like Police Service Commission and IG,
they are having issues.
Junior staff, PSC is doing everything and what have you. So like that of local government now, it is when it is changed. If not, issue of saying you have the money now, get it. The only quality people you can get, maybe consultants. I can give you an example. Most chairmen, they now succeed, especially in terms of projects, through consultant. Recently, I was a participant at Merit House when the Civil Society Committee in House of Reps organized a 2-day seminar for local governments from North Central on how to assess foreign donations as well as foreign contributions and donor agencies where they can also use for projects and what have you. So the issue I'm saying is if they really want to do it well, then the local government chairman can now get quality consultants. Like in FCT, when Erufai became minister, he never relied on productivity of FCTA staffs. Most of the jobs that were done by consultants.
Because he believed that they would not give him what he wants.
So since they have limitation to recruitment, the local government can also seize opportunity of getting quality consultants who can achieve in terms of drainage problems, healthcare projects, primary health care, educational, school building, and also other projects that will, empowerment, skill acquisition, and other projects that will improve the livelihood of inhabitants and local. Because that non-performance of local government made migration from rural area to urban center to be a geometrical from which ought not to be.
All right, Barrister, what will you say on this, the recruitment process? You've had Comrade Salihu here giving tangible examples as to why local governments are finding it very difficult to perform. Do we need another law which will empower local government chairmen or, and you can grow seamlessly right from maybe grade level 01 or 02 or 03 up to the highest position you can attain at the local government level?
I would start with the first one, the one he said, like the treasurer being, he will have his allegiance with the state government. You see, I know the approval of funds is the chairman who has the right to approve funds as allocated for whatever project or how they should be spent. Any chairman who knows his duty and know his powers will know how to sanction a treasurer that aid from his direct. I don't think any treasurer could just approve or remove funds without the approval of the chairman. I'm just bringing this scenario because our laws are there and there are ways to write and check where somebody committed such things. I'm bringing this scenario just to show that, yes, it's understandable that the allegiances must be there. But the system, if you look at the system properly, unless if that chairman is not worth his salt to know his powers.
Who said I should do it? I don't have power to challenge him. I think this is where Comrade Salihu is coming from.
Hello?
Yes, are you with me? Hello?
Yes, I can hear you, but not audibly. What I'm saying, on the other hand, I'm not saying that chairman and other have blank check to be that independent. I know there are allegiances of parties, fear and what have you of being a candidate, and the parties are in the hands of the governors. All those fears are there, but all the same, the system is there. If we get the party politics correctly, we won't be having these problems. And the election, we said that maybe the kind of people we are having in offices are not the kind of people that can man the local government properly. Well, it's a democratic system, and I hope to see in the day when people are very wise in having their candidates, and even political parties would, come to their senses in serving, the citizen, because the judgment we have to give goes a long way, because you will see the ordinary people will be very happy with this judgment as opposed to the governors of the states.
Okay, let me have your final take before I come back to the studio to round up. What will you recommend for President Tinubu to pursue? Is it to now transmit the power to conduct election at the local government by INEC, or you think there are ways to strengthen state independent electoral commissions so that they will not be influenced by government? I want you to answer this in less than 1 minute, please.
Well, President, that power must, that is beyond the powers of the president alone, because it's a constitutional amendment. And it involves the governors, the state governments, two-thirds, and what have you. But in my opinion, I would want to see that the local government elections are conducted by INEC.
Very good. Thank you very much. It's like we are coming to a convergence point between you and Barrister. He said he will also love to see INEC conducting local government elections. Don't you think INEC will be overburdened?
No, I don't think so. INEC has a team of some of the best trained staffs. Presently, they have a structure. Do you know in every local government you have INEC office? In every state capital, you have their state office.
So they can conduct it?
Automatically. Those in local government can conduct local government elections.
All right. Thank you very much, comrades Salihu Mahmud, for coming to the studio and for your informed perspective. And thank you, Barrister Umar Aminu Kalgo, the Secretary, Nigeria Bar Association, Birnin Kebbi branch, for joining us via Zoom from Birnin Kebbi. We thank you for coming to the program. And viewers, that's a wrap on today's package. We sincerely hope you found the conversation engaging and informative. And be sure to join Daily Politics Live, airing every weekday, and also our special package on Friday, during which we open the telephone line for you to comment on national issues. Once again, I'm Hamza Idris. Bye-bye for now.